This week on the Lectures in History podcast, University of Alabama professor Lawrence Cappello examines how the Supreme Court has defined and redefined Americans' right to privacy. Focusing on landmark cases involving police searches and government wiretaps, Professor Cappello traces how the court balanced law enforcement powers against constitutional protections and how evolving technology has challenged traditional interpretations of the Fourth Amendment. More in a moment.
All right, today we're digging into the Fourth Amendment with a particular focus on what it means for our phones. As you all know, the Fourth is part of the Constitution that protects you from unreasonable searches and seizures by our government. But the trouble is that the amendment was written in the 18th century. Meanwhile, our phones are basically mini supercomputers slash cameras slash journals slash credit cards slash surveillance beacons, and we carry them all around voluntarily all the time. So what happens when these two worlds collide? What happens when old language and old ideas meet new technologies? I want to start by breaking down the text of the amendment because there is a lot going on there. Off the bat, it's not just broad. It says very specifically, Americans have the right to be secure in their persons, houses, papers, and effects. That's specific language. So that's you, that's your house. Papers are essentially, I don't know, think of it as your emails right now, which is people would collect their correspondence. And then, of course, your effects, which is just another way of saying your stuff. The one thing I really want you to pay attention to is these are tangible things, and they were written in the 18th century as tangible things. Is your data an effect? Maybe. Are your emails, is what's in the cloud an effect? Maybe. Something we'll talk about. Also, it doesn't just protect you from searches and seizures by the government. It protects you specifically from unreasonable searches and seizures. That first word is very slippery. It's broad. What's considered reasonable, what's considered not. But unreasonable searches and seizures, we talked about plain view doctrine before. If a police officer is walking by your house and the windows are open and there's a brick of heroin and an RPG sitting on your table, yeah, they don't need a warrant. They're going to be able to just go in and do it. Unreasonable searches and seizures are something different. The last thing I really want you to keep your eye on is this issue of the warrant provision. The Fourth Amendment does not say the government can't go through your private life, your private home, and invade your most private precincts. What it does say is police can't do that without a warrant. So essentially, law enforcement, anyone know what branch of law enforcement works for? It's the executive branch, right? You have either a mayor, police commissioner, something like that, a governor, or if you're talking about the executive branch, through the FBI. So one branch of government, law enforcement, which is the vanguard for investigations, they think something's going on, some criminal activity, they want to look at somebody. They're not allowed to just act unilaterally. The Fourth Amendment says they have to go to a judge, a legal expert, and they have to get a warrant. And they're going to have to establish probable cause. So they can't just walk up to the judge and the judge is like, why do you want to get in this guy's house? And he's like, I don't know, I just have like a gut, it's a hunch, I follow my gut. The judge is going to be like, absolutely not, right? That's not going to work. This isn't TV, it's not the movies. You have to establish probable cause. You have to establish some pattern of suspicion that a judge is either going to agree or not agree on. And before they give you the warrant to go after what you want to look at, you have to swear an oath. And you know what happens when you lie to a judge? That's called perjury, and it's against the law. So there are a number of things happening, but one thing to really pay attention to is that last part. It's not saying that the government can't go through your most private effects and the most private aspects of your life. What they're saying is law enforcement can't do that unilaterally. They need to go to a legal expert. Two branches of government, the executive with law enforcement and the judiciary with judges, are both going to look at it, and then they're going to agree whether to greenlight it or not do it. The founders were very, very held the idea of the sanctity of the home and the sanctity of private property to be sacred. And they understood the government would sometimes need to invade those things, but definitely not kind of just lightheartedly, that there would have to be a lot of hoops to jump through before that can happen. But before I look at these three cases, I want to look at things that deal specifically with your phones. That's Olmstead from 1928, Katz from 1967, and Carpenter versus in 2018. We're going to do Olmstead and Katz today, and Carpenter, which is about tracking your cell phone through all of the cell site towers that are apparently everywhere. Sometimes they're painted like trees. We're going to talk about that next class because it's complicated, and it deals with a legal concept called third-party doctrine. But all three of these cases, Olmstead, then Katz, then Carpenter, are regarded as major cases in American constitutional history. And while they're about phones, they're not just about phones. Together, these cases have been incredibly influential in shaping the larger evolution of Fourth Amendment jurisprudence over the 20th and the 21st centuries. Now, the Fourth Amendment today deals primarily with illegal searches of homes by police. But there's all of these core cases that help expand the Fourth Amendment beyond the original text in the name of a right to privacy and in the name of liberty and freedom from government oppression. As a civilization, as Americans, we've come to view the Fourth Amendment as something that recognizes our privacy, the need for our freedom to be protected in the face of rapid technological progress. We live in a wondrous technological golden age, but there's no way that the framers of the Constitution ever could have anticipated technology from our modern world. When Madison writes the Bill of Rights, he'd never seen a photograph, and he'd never heard recorded sound before. The founders didn't even know what an audio recording was, let alone conceive of like an iPhone 17 Pro or with like Life 360 that's connected to a cloud that's also kind of like your credit card, but also like has ChatGPT on it, right? This is a concept that you can't expect the founders to deal with, but what do we do? Do we pass new laws? Of course we do. But to what extent can we look at the blueprint that is our Constitution for what the founders might have done with this as well? Because despite this, or maybe because of this, the Fourth Amendment has evolved over the centuries to meet the growing privacy and liberty threats that technology faces. And as these three major cases, they have a lot to do with that progression. First up is going to be Olmstead. This is a Supreme Court case from 1928. It's the first to deal with police and wiretapping. Show of hands, anyone know who invented the telegraph? The precursor, the first phone, kind of. Yeah, Samuel Morse. Samuel Morse introduced the telegraph in the 1840s, and like 5 minutes later, people began figuring out ways to intercept the messages that ran along across its wires, which makes sense. Information's valuable. I'm sure you've learned in college, knowledge is power. Information is also a commodity. It's something that you can buy and sell. And the ability to listen to conversations that other people think is private can have a multitude of benefits. Back during the Civil War, the Union and Confederate armies both started intercepting the telegraph communications of their opponents to get a tactical advantage on the battlefield, learn about supply lines. Confederate General Jeb Stuart, he even boasted about having his own wireman that was like attached to his company that he would be able to go around and constantly use for wiretaps. Later, Gilded Age newspapers, that's yellow journalism, remember that? Like Spanish-American War and all that stuff you learned in high school. They would constantly intercept each other's wire transmissions to try to like outscoop one another. So this technology exists very, very quickly. People start figuring out, wait, there's some valuable conversations going on in these lines. I want to figure out what's going on. Now, telephones, they entered the public mainstream basically in the early 20th century. They're very different from the person-to-person interface that we use today. When they're introduced, they're much simpler. See all these wires? It's because the technological and financial constraints of the early telephone era made it so that all of the phones were kind of looped together in a single network. I don't mean network like Verizon or T-Mobile. I mean network as in all of the phones in your neighborhood were connected to each other. And there was no switchboard to kind of move them back and forth. These are called party lines. Do you understand what I'm saying? You picked up your phone and everyone in your network in your community was on the phone at the same time. So if you wanted to have a phone call, you would meet someone in person and be like, hey, I'll pick up your phone at 7:30. And they're like, all right, cool. And then they come in and pick up the phone. Except, do you have a really expectation of privacy there? No, because obviously there are people who are bored who are just sitting at home listening to people's phone calls all day, 24/7. These are called party lines. It's the early way telephones did their thing. But my point is, picking up the phone in the early 20th century, nobody thought that that conversation was going to be private. And if they did, you were stupid. You just were completely out of touch with the way these things worked. Party lines were very popular and it was cheap. But eventually, people started pushing for more and more to their phone companies this demand to have one-on-one conversations. Obviously, you can't set up direct phone lines between people's houses on a large scale. It's not like kids with cans and waxed wires next door to each other. It's complicated. So eventually, what the phone companies do is they create a system that's centralized and has automated switching. This is the rise of the American kind of iconic operator who's switching calls from back and forth. And this is revolutionary because now you can connect calls between callers. The operators wouldn't stay on the line a lot of the time. And this would be a secure connection between two individuals. And as the 20th century progressed, this has become more and more like the norm. And it's revolutionary. It proves to be very profitable for phone companies. And while it doesn't eliminate party lines completely, it does pave the way to this established social expectation of privacy for telephone communications. And then finally, by the 1920s, if you're talking on the phone, you can expect that your conversation, for the most part, is going to be a private one. But this development, it cuts both ways. Because if people now know that phone conversations come with the expectation of privacy, it means that people are aware that more intimate details are being shared over these phone lines, and people start actively tapping these phone lines, just like they did with telegraphs. Businesses, private individuals, law enforcement, they're quick to take advantage of the benefits of listening to phone conversations held by people who thought that they were speaking in private. Which brings us to this guy. This is Roy Olmstead. He is a gangster. His nickname is Big Boy Roy. And Big Boy Roy is a bootlegger. You know what a bootlegger is? There's that 10-year period where we all lost our minds as a civilization and decided to pass a constitutional amendment to ban alcohol. Don't get me wrong. I'm not saying dry county shouldn't be a thing in the democratic process. If your community votes and they want a dry county, cool. What I'm saying is the Constitution is a different level, right? It's something that's kind of different. Whatever. This is my opinion, not established fact, but I don't think it's a controversial one. Anyway, Olmstead's really, really good at his job. He's a very successful bootlegger, and he runs this large operation out of Seattle. And what they do is they smuggle Canadian booze by sea through a navy. He had like a navy for distribution for the United States. I know we hear all these stories in like our lore about like moonshine and bathtub gin and stuff like that. Well, that definitely existed in a lot of parts of the country. If you really wanted to make money in booze during Prohibition, you just imported good stuff. That's what people wanted. That moonshine also, you know, it's inconsistency in terms of taste, but also in terms of strength. You drink it, you can go blind, right? It's like, it's not that standardized thing that you want. So if you're importing booze, that's how you make money during Prohibition, and this is exactly what they're doing. Remember your map, Seattle's like right there, Canada's right there, you're just like, over, and then there you go. Suddenly you have booze to sell in America. He's so good at his job that investigators estimate that the organization takes in profits of around $2 million a year in 1928 dollars. So it's a massive operation. Now, Olmstead has a lot of conversations in his house. This is the actual house, and there are phone lines running into the house, and he makes calls to coordinate things because he's kind of in charge of most of the operation. And he has a home office, and he coordinates a lot through his home office. So the feds go outside of his house, install a wiretap on his phone line that goes directly to his home office, and they get everything they want and more. It's an absolute coup, major career case. It's a case that eventually results in the indictment of more than 70 people. You have bookkeepers, you have secretaries, you have attorneys, you have salesmen, you have a number of corrupt Seattle policemen. If you're in the feds and you're on this is a career case. This is something that's going to help get you promoted. It also makes major headlines. The scale of it, the scope of it, the fact that like gangsters was becoming a really, really popular embedded in our popular culture. It was just a sensational story all over national news. But, and this is a big but, the feds never got a warrant before installing the wiretaps on which Olmstead's conviction depended. And so this left a window for Olmstead's lawyers to appeal on Fourth Amendment grounds. Remember, the Fourth Amendment says you need to get a warrant before messing with somebody's persons, houses, papers, and effects. Olmstead's lawyers are like, hey, you essentially penetrated my client's home office without recording devices, and the Fourth Amendment says you need a warrant to do that. And there's a clear constitutional dilemma here, so the Supreme Court eventually agrees to hear the case in 1928. And this puts a lot of interesting questions before the court. This is the Taft Court. Former President William Howard Taft ends up leaving the presidency after his term is over, and then, you know, most people just do speaking tours and like hang out and get their library built. He's like, I think I'm just going to be Chief Justice at the Supreme Court, and then comes in and just makes a stamp for another 10 years. This is the Taft Court. And it makes sense that they would take this case because it is an interesting constitutional question, and it's why the court kind of exists, is to settle these kinds of questions. And the question is, does the Fourth Amendment just protect property and like tangible things, things that you can hold in your hand, like it was when it was written? Is that what this is for? Like a person's home or office? Is something that's intangible also protected against searches? Are wiretaps exempt from the Fourth Amendment wire requirement because they're not involving a physical trespass? They didn't send a wireman into this guy's office ninja style at night in like a black mask when everyone was sleeping and like, you know, put in microphones and things like that. It wasn't like that. It was hung it outside a phone wire that wasn't even in his house. Olmstead's attorney says that the police acquired evidence in his home without a warrant, and therefore this is an illegal search under the Fourth Amendment. He's asking for a broad reading of the Fourth Amendment, what we call loose constructionism, to include the protection of all activities that take place inside the home, including telephone calls. Olmstead basically says, because I made my calls from my home under the belief that they were private, law enforcement agents intruded on that privacy, and I had a constitutional right to be protected from unreasonable searches and seizures that don't have a warrant. Now, arguing the other side, prosecutors are like, yeah, we completely disagree with everything you're saying. We didn't do anything inside this guy's house. We went outside this guy's house. There's absolutely no Fourth Amendment problem here. We didn't mess with anyone's persons, houses, papers, and effects. We installed a wiretap outside of this guy's home. We never penetrated the space. And again, the text says what it says, and it doesn't say what it doesn't say. And persons, houses, papers, and effects, none of that was involved in what we did. According to the government, a wiretap's not a physical trespass, and therefore it's permissible without a warrant, and there's no Fourth Amendment violation that exists. It's a tough one, and it's close. It's a 5-4 decision, and the court denies Olmstead's appeal and upholds a narrow interpretation of the Fourth Amendment, basically saying that because there was no penetration of the space, physical things, there was no searching, there was no seizure, says the Chief Justice. Evidence was secured only by the use of sense of hearing, and that only. There was no entry of the houses or offices of the defendants. Taft is not unsympathetic. He's not just entirely unthinking on this matter. Taft actually thinks that there should be laws protected against this. He finds wiretapping to be very alarming. He thinks that it's introducing a new age of the potential for the government to invade people's privacy. But Taft is ultimately a judicial conservative, which means he believes that it's Congress's job to pass a law or pass a constitutional amendment or update the Fourth Amendment, that they can't just take the Fourth Amendment and provide a broader reading, that if wiretapping offended the public conscience, that Congress, the people's branch, should pass a law including new kinds of technology, and that should be what they would have, and then there wouldn't be an issue in terms of the Fourth Amendment. Now, the dissent is penned by one of the most famous justices to ever sit on the Supreme Court. Now, look, getting a job on the Supreme Court's a really big deal. I mean, it's the first byline on your gravestone and definitely the first thing on your obituary. But there are a lot that don't tend to loom large in American history. Some do, some don't. Justice Brandeis, who penned the dissent, is one of the ones that tends to live on. You will read Justice Brandeis if you go to law school. He is one of the most popular Supreme Court justices, not just of the 20th century when he was on the court, but largely in the history of the institution. Brandeis, before he was on the court, when he was a young, recent law school grad that just went into private practice, he wrote a Harvard Law Review called The Right to Privacy in the 1890s, which is one of the first ever major legal tracts to be written about privacy. And what he says in 1890 is, technology is getting crazy. And you have all this new photographs coming out, and you have different ways of printing that are going on, and that the law needs to keep pace with technological change. And that we have to start looking at privacy as not just private property, but that's something that's bigger, that it deals with what he calls inviolate personality, what's going on inside with people. Brandeis, now that he's on the court, still has that kind of zeal for protecting American privacy. And what he says is, look, the founders absolutely would have wanted the Fourth Amendment to cover wiretaps. That we know who they were, we know their writing, they very much were afraid of this idea of overt government intrusion in people's houses, and wiretaps definitely fall into that purview. And what he says is that there's more far-reaching ways of invading privacy that have become available since the time of Madison when he's writing the Fourth Amendment. And he says that discovery and invention have made it possible for the government by means far more effective than stretching on the rack. Do you know what that is? Brandeis getting a little melodramatic here. That's when they medieval torture, stretching you out to get kind of like a confession. So what he's saying is a wiretap is worse than that, which, I don't know, I'm a privacy advocate, but let's be real, I'm not trying to hang out on the rack. So to obtain disclosure in court of what's whispered in the closet. He had a famous quote in a different decision where he said, what is whispered in the closets will be shouted from the housetops. That basically Americans' private thoughts, sensations, and the things that happen inside their homes because of modern technology would then be broadcast and available to the government, and that this is something the Fourth Amendment, of course, was meant to protect. That the Constitution, as we said a lot of times, it's not a municipal code, it's a blueprint. It's about what were the founders trying to do in broad terms, and he believes ultimately that the Fourth Amendment should be capacious enough to do that. When you think about it, he was dead right about technological progress. This dissent remains one of the most widely read tracts in American legal history. Generations later, a very different Supreme Court, 40 years later, will actually borrow very heavily from this when they do extend Fourth Amendment protections to wiretapping when this case is overturned. A little side note, the decision was also really unpopular in a lot of influential circles. The American people didn't really like the idea of wiretaps and the government listening to their phone. They also, a lot of them didn't love the idea of the Fourth Amendment not covering telephonic communications. So years later, Franklin Roosevelt, FDR, when he's president, ends up pardoning Olmstead. Olmstead, after being released, has an interesting life. He goes around and becoming like a public lecturer. He gets really into Christian Science. I don't know if you're familiar with what that is, which in the 1930s was absolutely having a moment in American public consciousness. He became one of the big leaders of that movement, a massively popular public speaker and kind of very much a minor to mid-level celebrity in his day apart from that. But FDR pardons him. Nevertheless, the Fourth Amendment remains untouched because of this decision. Now, the Olmstead decision was not current law. It was then, it's not now. The case that ends up being overturned 40 years later, and the case that impacts your life when it comes to this stuff, is Katz versus the United States. This time it's not a bootlegger, it's a bookmaker. Raise your hand if you know what a bookie does.
C-SPAN's Lectures in History podcast continues in a moment. Now back to C-SPAN's Lectures in History podcast.
Your phone's basically your bookie now. Back in the day, if you wanted to bet sports, whether it was South Carolina versus the Tide, which you can't do in Alabama, but you can in other states, if you wanted to play the ponies, if you wanted to, whatever. There was a guy that was hanging out in a corner store or a pizza shop or something like that who was kind of never left and always had a bunch of forms in front of him, and you went down and you got to lay a bet. He's a bookmaker. Is betting on sports illegal? Kind of. You have to go to people who have gaming licenses. You can absolutely bet on sports if you want to, but you have to go through appropriate legal channels. It's a state level thing. There are gaming boards, also where you are. You can't just be like, I'm taking bets, right? That's against the law, and that's what Charlie Katz is doing. So he's an illegal bookmaker, and the FBI realizes that he's running a nationwide illegal gambling operation out of Los Angeles. Agents from the Federal Bureau of Investigation regularly, this is an actual photo, regularly observe him using a public payphone. You guys know what a payphone is? You've seen like movies and stuff like that, right? The feds believe that he's using one payphone in particular to relay gambling information relating to his book. So without getting a warrant and without entering the phone booth, the agents attach a listening device to the top of the booth. There's like little air vents that are there, and they put a little microphone on top of the booth so they can hear what's going on there. And they start recording Katz's conversation. Obviously, it's just one way. All you're getting is what Katz is saying because they didn't tap the line. But he's calling Boston and he's calling Miami, and once they have enough evidence, he's arrested and he's prosecuted for transmitting wagering information via telephone over state lines and coordinating illegal money operations through gambling across state lines, which is absolutely the FBI's purview, and it's absolutely a violation of federal law. Just like Olmstead, Katz's attorney basically says, did you get a warrant? And they're like, we didn't need a warrant. And he's like, I think you needed a warrant. And so they file an appeal, just like Olmstead's attorney did, and they say his conviction should be overturned because the evidence against him is gathered in an unconstitutional manner. Basically, there's no warrant. Again, in 1967, the case comes before the Supreme Court, and there are two distinct arguments. Katz's lawyers really obsess over the phone booth. And they're like, look, we get that the phone booth is a public area, but once it's used by someone and a client, it becomes a private space. And that it's a constitutionally protected area because we're talking about personal things. Essentially, they said a phone booth is a constitutionally protected area just like a home or an office. And the courts in Olmstead were like, yeah, this isn't the case. And they said, right. And we think Olmstead was decided wrong and should be overturned. It was 5-4. Justice Brandeis wrote this excellent dissent about why this is a problem. And we believe this conviction should be overturned. They said a person's private conversation should remain private wherever you are unless proper procedure is followed, including the use of a search warrant. The prosecution said, yeah, this isn't true. A couple of things. One, it's a phone booth. It's a public phone booth. So the fact that you're saying this is a constitutionally protected area makes no sense to us. Two, this has already been decided. Olmstead versus U.S. I'm sorry you didn't do your homework, but at the end of the day, the Supreme Court weighed in on this. We were following procedure based on existing law. The existing law said that unless it was persons, houses, papers, and effects, we don't need a warrant. So we didn't get a warrant. We don't feel like we did anything wrong. So there's this constant kind of discussion over whether a phone booth is a constitutionally protected area, should it or shouldn't it? And that's also kind of weird. As someone who was there, I will say that phone booths did have a certain privacy expectation. I wasn't there with like Katz. I mean, there when phone booths were a thing. If you were on the phone booth and someone wanted to use it after you, they didn't just like stand next to you. It would have been seen as weird, and you would have been within your rights to be like, can you back off for a second, right? Or you would have like turned the phone away. You could gesture, you could, flip your coin, you can kind of like show them that you're impatient, but you're also expected to stay a couple of arm lengths away from people. Someone standing next to you on the phone would be the same thing as someone outside standing right next to you when you're on your phone, right? If you're having like a phone conversation. That said, it's not your phone, right? Like you're out in public, people can see you. It's a big glass box. That's even if you're lucky enough to get the box. Like a lot of them were just on a pole somewhere and you were standing out in the middle of the street exposed to the elements. So everybody is like, is a phone a constitutionally protected area? Is it not? And eventually the court's like, oh my God, shut up about phones. They're like, we're not talking about phones. We're not doing this at all. 7-1 vote. The court overturns Olmstead's precedents and Katz's conviction along with it. And what Justice Potter Stewart says in this very, very famous line is that we're not going to have a debate over whether or not a payphone is a constitutionally protected area. That's not the thing that's important here. Stop focusing on phones. Stewart said that the Fourth Amendment was meant to protect, quote, people, not places. Again, the Supreme Court in a 7-1 ruling says the Fourth Amendment at the end of the day, when you want to understand what's going on, it was meant to, quote, protect people, not places. And that as long as an American has, quote, a reasonable expectation of privacy, you're covered by the Fourth Amendment. We're not going to have these details and these constantly long arguments about what qualifies, what doesn't qualify. If you have a reasonable expectation of privacy, you're protected by the Fourth Amendment, and it doesn't mean that law enforcement can't get in your face, but it does mean that they need a warrant if they're going to search your things that you regard as private and that we as society agree is private. They didn't get a warrant, they didn't have a right to invade his privacy, and therefore Olmstead's decision is overturned. Now, the founders did say that the police shouldn't have the authority to make those kind of decisions on their own, that if you want to invade the privacy of Americans, just speak to a judge, a legal expert, and if they agree that there's probable cause, you can just get after it. And that's the thing with Olmstead and with Katz. Both of them were guilty in the sense that both of them were committing these crimes. Olmstead's absolutely a bootlegger. Charlie Katz is absolutely a bookie. And the probable cause that they had were standard. Law enforcement that worked these cases were really good at their jobs. They chained evidence. They found coordinated, sophisticated operations, and then they brought them to trial. They just didn't get a warrant first. If they went to the judges, they would have got it. This wasn't some kind of 1984 cabal situation. I mean, these are cops doing their jobs and doing it well. But this idea of making sure you go to a judge is important. And it's something that even in these cases, the Supreme Court now has been emphatic about. This creates what privacy scholars, I'm a privacy professional, call the golden rule. And this is the current privacy law that you're subjected to right now. If you think your privacy has been invaded and you file a complaint, the judge or whoever is adjudicating the case will first just ask, did you have a reasonable expectation of privacy? If the answer is yes, then hey, maybe you make a little money, or maybe someone goes to jail. If you didn't, then you don't. And this is the common standard of now American privacy law. And you see how it aligns with the Fourth Amendment? Because the Fourth Amendment doesn't protect you from searches and seizures. It protects you from unreasonable searches and seizures. So do you see how this is still aligned with the language of the Fourth Amendment? When you have a reasonable expectation of privacy, then a warrant is needed before the government is allowed to penetrate your private space. And this seems simple enough. But is it? What does that word even mean, reasonable? Give me a show of hands. If you think this is a reasonable expectation of privacy, if you send an email from your University of Alabama account and you're connected to the university Wi-Fi, do you think you have a reasonable expectation of privacy? Hands up if you think you do. You don't seem convinced, right? It's not your account, it's not your Wi-Fi, it's a professional work kind of thing, right? Most people, I would say, in America would say you didn't have a reasonable expectation of privacy, and if the university, you end up getting in trouble by the university for something you emailed, and you're like, hey, you shouldn't have looked at my emails. They're like, I feel like they should have had the right to look at them. Right? Most people wouldn't go for that. What if you were on your cell phone, on cell data, you're not using university Wi-Fi, on your Gmail, and you send an email, and the university tries to get access to it? Raise your hand if you think you had a reasonable expectation of privacy. Everyone agrees, right? This is easy. Privacy law is super simple. All right. It's your phone, it's your Gmail, you're connected to university Wi-Fi at your own. Do you have a reasonable expectation of privacy? Not what do you want. What do you think the law and a reasonable standard? Raise your hand if you think you do. Raise your hand if you don't. Yeah, it's kind of 50-50, right? This is the slippery slope of privacy law. If any of you are interested in this kind of field, like what it looks like, it's about establishing what's a reasonable expectation. And at the end of the day, who's going to establish what's reasonable? We are, as a civilization, like as a people, right? Like as a society, we're all going to basically decide whether or not something's reasonable. And I promise, like a reasonable, internet generation, what's reasonable in terms of privacy to us is very, very different from what your grandparents thought when they were your age. Standards change. Cultural norms change. We go through big moments. If anything, things are changing faster than they ever had in the entire history of this nation, right? Standards and norms, not even just intergenerationally, but within the generations. You have like tiers, elders and babies and things like that, right? Within the generations that exist. So knowing what now as opposed to what's there before isn't easy. It's something that's relied on in case law. It's about checking out standards. But what I'm trying to say is that if the Fourth Amendment is based around this idea of a reasonable expectation of privacy, and what's reasonable keeps changing and evolving, do you understand the Fourth Amendment keeps changing and evolving? That it's constantly shaped and adapted to the kind of modern standards at our time. I want to unpack this for a moment. because I'm a big fan of the Fourth Amendment, and I think it's great, but it's certainly not clear-cut in the same way unreasonable isn't either. Take your phones out. Raise your hand if you're on Snapchat. Everybody, open up your Snap. Open up your My Eyes Only. And I want you to swap phones with the person behind you for 5 minutes. If you're not doing anything wrong, you should have nothing to hide, right? What are you doing? Obviously something. None of you did it. Not even one angel among you. The ones with like nothing in it are like, haha, right? Like, you know, some people, some friends you have never have a browsing history ever. And you're like, really? You never go on the internet? You're like, never. If you're not doing anything wrong, you should have nothing to hide, right? Why do we have a Fourth Amendment to begin with? Yeah, obviously, if you studied the constitutional history, the fact that the British were kicking down doors during our revolutionary period really is something that burned bright with the founders, right? And this idea of a colonial or magisterial redcoats coming in and invading the privacy of, you know, the good patriots, like, I get that's what's there. But also, like, let's look at this from a pro-law enforcement standpoint, right? If you're not doing anything wrong, you should have nothing to hide. Because there are people that are trying to kill Americans, whether it's internally through violent crime, whether it's internationally through the many enemies that we have who 20 years ago flew planes into buildings and are still actively trying to kill, right? Like, the threat is real. The world is dangerous. Americans are targeted. If you're not doing anything wrong, you should have nothing to hide, right? Oh, you have an embarrassing photo? Come on, we're trying to stop terror. Anyone have a response to this? Raise your hand if you've heard this before. This is a very old argument. People in power have been using this since the time of the Caesars, or before the time of the Caesars, really. And when you look at it, it's called the nothing to hide trap, that we call this in the privacy community, and it's really, really, really effective, particularly if you're in charge of something and you have power over other people. Because let's dissect it from like a language perspective. Off the bat, aggressive, right? Out the gate, you're sus, right? Something's up with you, right? I need to see your device. And you're like, I don't know if I'm going to show it to you, right? Now, the more you try to assert your own right to privacy, what's going to happen? You look more suspicious, right? So you see it's like quicksand, which is a thing that as a child I thought would have like a larger impact on my adult life. But like it's this thing where ultimately you have this self-defense that just makes you seem more guilty. And eventually they're just like, you know what, I was kind of half kidding when we originally talked, but now I'm really worried. So I'm going to need to see your phone right now, otherwise we're going to have a serious problem. Now, this is hard to defend yourself from, right? And something that's been happening for a really long time. Now, the way you get out of the trap is actually pretty easy. This is what's called a logical fallacy. Brace yourselves. Anyone know what a logical fallacy is? Raise your hand if you've ever heard the term. Yeah, you can learn it from like Philosophy 101 or taking anything in terms of logic. A logical fallacy means that while it may look legit on the surface, when you start when you start dissecting the underpinning logic, it really doesn't really hold up to scrutiny. Look at the statement again. If you're not doing anything wrong, you should have nothing to hide, is really just a way of saying all secrets are bad. All secrets are sinful. All secrets are nefarious, right? That only bad people keep secrets. And so obviously if you have a secret, then there's something wrong and is there bad or an evil or a sin that needs to be uncovered. Is that true? No, not all secrets are bad. Not all secrets are bad at all. There's a lot that's going on. Secrets are absolutely necessary to navigating modern society. Now the law, for starters, gives you some basic ones. Doctor-patient confidentiality, attorney-client privilege. These are two things that our society actually gives legal protections behind those secrets because it's a really, really good thing for public health if you're honest about your doctor. Dude, your doctor, I promise you, like, if the doctor's like, do you do drugs? And you should be, don't lie to your doctor. He or she is trying to help you out. It's the same thing with your lawyer. They're trying to work things out. They need to create a space legally where you can be honest and open. So one, you get better treatment, and then the public at large ends up getting better treatment. But that's kind of easy, low-hanging fruit, doctors, lawyers. But there's a lot of other things. If we're going to call our right to privacy, our desire for privacy, the ability to limit access to your personal information, limiting access to your personal information allows you to protect your reputation. It allows you to shape how you're perceived by others. And secrets are absolutely a necessary part of navigating modern society. Job applications and career moves. A lot of times people apply for jobs before they're ready to leave the other one that they're at. And if someone gets found out in the middle of that, it can create a very non-strategic, destructive element for you. Financial information and credit information, relationship struggles, personal conflicts, political and religious beliefs in certain contexts, personal health concerns that aren't criminal or stigmatized, creative work, early ideas, intellectual property in progress, writers, artists, innovators in American business being able to keep something secret before they bring it to market. Secrets are absolutely a wonderful thing. Are there bad secrets? Of course there are. Are there adulterers and drug dealers and people who lie in a way that hurts other people and is detrimental to our society? Of course there are. But a lot of the secrets that we have aren't necessarily that. Secrets also create space for intimacy. Think about the best first date you've ever been on in your entire life. You meet someone, you're looking at them, they're looking at you, you start connecting, and one of the first things you might do is give a piece of personal information. Right? And if they maybe give you a piece of personal information back, it's a kind of currency. It establishes bonds and intimacy. Same thing you have with friends and family. Those bonds, that intimacy, it's maybe the best part about being alive. Like from a deathbed perspective, when you think about what matters, you're probably not going to stand there and be like, thank God I was able to get all that stuff. Right? Like at the end of the day, it's going to be those relationships and those intimacies, right? And your secrets are kind of the building block of that. Now, I don't really think Madison's talking about this where he's just like, well, you know, your ability to shape your reputation. They cared about their reputation, but that's not really what's on the founders' mind. That's what's not going on in the Fourth Amendment. Raise your hand if you ever read George Orwell. The nation of Oceania, if you remember, is a sprawling superpower. It's known throughout the world for its advanced technology. Within its borders is a vast network of telescreens. These are super flat tablets. They look like dull mirrors installed in every home and on every street to record the movements and the interactions of all of the citizens. Nothing escapes the eyes of the screens. The government had a ministry of peace, and they promised that the screens were there. Why? Well, for safety, obviously, right? To keep you safe, to prevent bad things from happening. But as time passed, anyone who criticized the government decision or whispered about the possibility of political change is either arrested or mysteriously disappears. Now, the true power of the telescreens isn't necessarily in what they see, but in the knowledge that they were there, that they were always watching. The lively discussions in cafes, in bars, in markets, that dwindles and eventually grows silent. Passionate debates over dinner tables ceases. And in the city, every evening is filled with people who had nothing new to say. Realizing that their innermost thoughts could be turned against them, the citizens of Oceania start guarding their minds and suppress any idea that might be seen as dissent. And this constant surveillance leads to a culture of self-censorship, where people are afraid to kind of voice their opinions or to assemble for any real cause. This is the wisdom of George Orwell's 1984. It's why every democracy in the world has laws on the books to protect citizens from overly invasive government snooping. Our strongest bulwark against that is the Fourth Amendment. That's the shield, that's the protection that our founders established to protect this kind of liberty. Because the book is fictional. It was written in 1948, published in 1949, but Big Brother is not fictional. Big Brother is very real, and the technology that Orwell was talking about didn't exist at the time, but it absolutely does now. The word surveillance, government surveillance, it's binary in nature. You know what binary means? It means two things at once. That is one of the hallmarks of the intelligence, to be able to hold two contradictory ideas in your head at the same time and navigate them. Think of this as a double-edged sword. On one sense, surveillance, to surveil. Our government watches us to keep us safe. And that's not unlike how parents watch over their children. And make no mistake, we need to be watched to be kept safe because we have very real enemies. Again, foreign and domestic, whether violent crime or terrorism or the full spectrum of harm that can come to us and the ones that we love, and the need for criminal justice, government surveillance absolutely helps save American lives. A lot of law enforcement's not like on TV. You have a shooting at night. There's no one around, there's a body on the floor, there's a car that drove away, no witnesses. And you have to tell that person's family, sorry, no witnesses, I got nothing. Or is there a CCTV camera on the street that maybe got a license plate that gives you a lead and allow these things to happen, right? It's a very real thing, very real actionable reality. And these things are there. And again, I'm saying this as a Fourth Amendment scholar, as a working privacy professional, not all government surveillance is evil, and it absolutely helps save lives. But like parents, governments also watch us to enforce their rules and to maintain their authority. And so government surveillance is about two things. It's about protection, but it's absolutely also about power. There are two kinds of surveillance, overt surveillance and covert surveillance. Overt surveillance is the eyes that we can see. When people know they're being watched, it creates what psychologists call a chilling effect. Individuals will often feel as though they can't act freely as they might under normal circumstances, which can negatively impact their sense of well-being, their creativity, and their individuality. Look, another way of non-academically saying it is kind of like Being watched all the time when you know you're being watched will blunt your sharp edges. It fosters monotony, it fosters conformity. And it has nothing to do necessarily, not nothing to do, but it doesn't always have to do with power. Do you guys drive on the interstate and just rock out? Do like just turn up the music and just like you are blasting hilariously to like your favorite song? Now, if you stop at a red light and someone pulls up next to you, do you turn it down a little bit? You're kind of quiet, sulk in your seat a little bit. Why? Shouldn't you just let your flag fly, right? Like just get out there, right? Music's in your heart. Life is short. Sing. Sing with passion, with vigor. Drink deep from the cup of life. No, because it's weird, right? And everyone else is going to think it's weird too. And is it weird? Well, what's weird? Whatever we're socially conditioned to be weird. But you shouldn't be ashamed of the fact that you find that, no, I'm going to keep it. When being watched, take a psychology class. When people know they're being watched, there's something called the Hawthorne effect. There's a lot of different words for it. When people in experiments know they're being watched, they change their behavior. When you understand you're being filmed, if you're giving a lecture, right? Like, obviously, there's something that constantly, right now as I'm being filmed, that I'm experiencing and that I'm feeling, and I'm wondering if this is the truest representation of myself, and what are the, right? But, like, it's there, right? And it fosters a certain degree of monotony. And this attacks our individualism. And this is a problem for Americans because individualism is a big part of who we are, because of culture, and whether you're liberal or conservative, red team, blue team, extreme, moderate, in the middle, and it's been like this for hundreds of years. Part of national cultures have different kind of aspects, and us being individualistic is, at once our greatest strength and maybe our greatest weakness, but it is one of the reasons why we're such a powerhouse of a nation. It's a big part of our natural culture. We are individuals. We believe in individual rights. And when taken too far, overt surveillance can kill individualism, free expression, and undermine the integrity of our democratic institutions. It makes people less willing to participate in political movements that push against the status quo by instilling a sense of fear that they might be penalized or even arrested for acting in a way that the powerful find very threatening. And again, this is true for liberals as it is for conservatives.
C-SPAN's Lectures in History podcast continues in a moment. Now back to C-SPAN's Lectures in History podcast.
Great liberal and conservative movements both usually started as nascent terms, as outsiders, as things that people were criticizing. And then as they developed time and popularity and were able to germinate and grow, they were able to then thrive and become an active part of the full spectrum of what is our American conversation and the debates that our politicians have and our society have and our culture has. Those things need individualism and a kind of freedom from overt chilling in order to thrive. It also inhibits the right of freedom to assembly we have guaranteed in the First Amendment. And this isn't some professional ivory tower academic theory. We see this all over the world from surveillance societies. We see it over and over again from nations right now on planet Earth that don't have strong protections against surveillance, don't have strong protections for American conceptions of liberty and privacy. You step out of line politically in a lot of places, you get arrested, just like our founders did when they were protesting the English prior to our revolution. Covert surveillance is the eyes that we can't see. And when people don't know they're being watched, the potential for a government to suppress dissent and neutralize political opposition is nearly limitless. Thankfully, we do have a crystal ball, the Orwellian images of high-tech government actors watching our every move. That's no longer the stuff of fiction. We can see pretty clearly what the future is going to look like if these practices are left unchecked. When you look at the surveillance societies that exist right now on our planet, which don't have the kinds of Fourth Amendment protections that we have, we see a lot of troubling things. If you're unhampered by things like constitutions or privacy laws, some governments can use AI-powered facial recognition technology, internet censorship, social credit scores, data mining to monitor the activities of almost every citizen, from their online behavior to phone calls to physical movements. And this surveillance, it targets and punishes individuals who express political dissent or engage in activities that are deemed too individualistic or disloyal to the government. The chilling effect on political expression and political opposition has been devastating in a lot of places, and it further erodes civil liberties and human rights in a lot of ancient and beautiful societies. The surveillance, think about the internet, think about what your phone does, shopping habits, browser histories, how much time you spend playing video games, whether eating, drinking, how much you're smoking, what you're eating, who you're drinking and smoking with. It's not just straight to jail. And again, it's not like Orwell, you just get disappeared. It's things like step out of line and suddenly your debit cards don't work for a week. We'll see how you like that. You want to fall in line? Your internet gets throttled for a month. Maybe your kids suddenly get disqualified from certain schools or jobs. An alert will pop up in the taxi you just got into, telling the driver that they're not allowed to take you past a certain distance because your travel has been restricted. In some cases, I swear I had to look it up, they'll take away your dog. Everyone's like, aw. The fiction is absolutely reality. The technology is here, the structures are in place. If used improperly by an ambitious tyrant, that person would be able to manipulate and undermine the fundamental principles of our republic. We're a nation that relies on the free flow of information, the ability of individuals to make informed decisions. And if you eliminate that, we're done for. Our laws, our votes, our collective vigilance are the only thing standing between us and an autocratic future. It is very much the intention of the founders that Americans watch the people who are watching us with unwavering persistence. This is absolutely the spirit of our Constitution and the spirit behind our Fourth Amendment. What you will want to avoid is this thinking that deals in false trade-offs. Anyone who starts speaking in zero-sum terms, well, you can have privacy or you can have safety, but you can't have both. No, that's not true. Well, you can have CCTVs or you can have criminals run free. Pick which one you want. That's not really true. There are a lot of third paths that people were able to navigate, especially with modern technology, where you can demand as an American your right to privacy and liberty while also demanding that your leaders keep you safe from harm. Anyone ever heard of ShotSpotter technology? This is a good example of that. So CCTV cameras can be on all the time, watching people in ways that are objectionable, also catch crimes, or they can be off and then there's no watching. There is a third path. They have them down in Montgomery. They have them in a lot of other places. They'll attach microphones to the end of CCTV cameras. Those microphones will be specially tailored to pick up the frequency of gunshots. So what happens is the camera's off, and then if gunshots register on the microphone, the camera switches on. You get it? Or if a crime has been recorded in a certain area, someone calls 911, hey, I saw this, I saw someone being attacked, I saw someone being tackled to the ground, and immediately then you can switch on the cameras, given a certain area. Do you see how that is threading a needle, where you can have the benefits of these things while also not just dealing with, cameras being on all the time in some Orwellian sense? This is just one example of 1,000 of things that privacy professionals do, what privacy law tries to deal with. Zero-sum thinking, people who talk to that are usually lying or trying to sell you something. You can either have privacy or you can have, no. You're Americans, be greedy. Expect your cake and have it too. You absolutely get to have liberty and privacy and all of the things that you were given by the founding fathers through the Constitution and the rights that they recognized, while at the same time expecting robust public safety measures. What we need to ask leaders is to ensure that they're able to do both at once, and that they should come up with third path and third solutions. And you can remind them that they really went around for a long time convincing people that they should be in charge before they got elected, and so it's not too hard of a task. Zero-sum thinking, zero-sum thinking, black and white thinking about these issues, that's un-American. All privacy all the time? No, it's not realistic. You kidding me? We're all gonna go live in a cave and I like my laptop, I like my phone, I like my credit cards. I do this for a living. I'm not getting rid of my devices. At the same time, I'm also not wearing the tin foil with the thing right on my head. That's not feasible in the 21st century. Of course, you're going to sacrifice certain privacy. But this idea that you sacrifice all of your privacy, all of your protections that come in the Fourth Amendment, and then the larger spirit of the Fourth Amendment, simply because you live in a wondrous technological golden age, well, that's not true either. There are third paths, and that's largely the challenge of the 21st century. How do we enjoy the benefits of these things, the increased safety, the increased convenience, the increased innovation, while also ensuring that we don't fall afoul of the spirit of the Fourth Amendment and what our founders intended us to have. Next class, we're dealing with Carpenter versus the US. This is a class specifically that deals with cell site location information and the fact that, your phone is always pinging, it's a term, like a cell tower, and that those records just exist kind of in perpetuity, and I can't, but if you had access to it, you can backtrack. Anyway, we're going to talk about whether that's legal and whether that requires a warrant. Carpenter is a really complicated case. It deals with something called third-party doctrine, which is why I didn't set enough time for it today. But otherwise, we'll deal with that. You have assigned readings. Thank you.
To find more of our history programming, visit our website at c-span.org.